Welcome to the lesson on the Doctrine of Competence-Competence. As usual, the learning materials for this topic can be found in the description below the video in order of appearance. The Doctrine of Competence-Competence is a foundational concept in international arbitration, allowing arbitral tribunals to rule on their own jurisdiction. However, the extent of this autonomy remains contested, particularly regarding the role of national courts in reviewing or setting aside arbitral awards. One of the most significant cases in this area is Dallah Real Estate and Ministry of Religious Affairs of Pakistan, decided by the UK Supreme Court in 2010. The case clarified the scope of the doctrine in English law and raised key questions about the balance between tribunal independence and court oversight. Background and facts of Dallah. In 1994, Dallah, a Saudi Arabian company specializing in Hajj travel, entered into a memorandum of understanding with the Pakistani government. Under the memorandum, Dallah acquired land in Mecca to develop housing for pilgrims to be financed by a trust created by Pakistan. The parties agreed that any disputes would be resolved through ICC arbitration in Paris. Disputes arose when Dallah exceeded its agreed investment and the trust ceased operations. Dallah initiated arbitration, claiming Pakistan, as the backer of the trust, was effectively a party to the arbitration agreement. Pakistan denied this and did not participate in the proceedings, asserting its sovereign immunity and lack of consent. Despite Pakistan's absence, the ICC tribunal assumed jurisdiction. With no express choice of governing law, the tribunal applied principles of transnational law and concluded that Pakistan was a party to the arbitration agreement. The tribunal issued 2 partial awards in favor of Dallah. Dallah then sought to enforce the award in the UK, but Pakistan resisted enforcement. Dallah contended that the New York Convention 1958 did not allow revisiting the tribunal's merits at the enforcement stage. The matter reached the UK courts. The UK High Court refused enforcement, stating that there was no valid arbitration agreement between Dallah and Pakistan. The case was appealed to the UK Court of Appeal and ultimately the UK Supreme Court, which upheld the High Court's decision. The UK Supreme Court clarified that while the Doctrine of Competence-Competence grants tribunals initial authority to determine their jurisdiction, this authority is not exclusive or final. Note that under Section 103(2)(b) of the UK Arbitration Act 1996, reflecting Article and of the New York Convention, English courts are entitled to review de novo whether a valid arbitration agreement existed. The UK Supreme Court emphasised that courts have a duty to ensure awards are not enforced against parties who never agreed to arbitrate. Although the tribunal applied transnational law, the Supreme Court held that French law, as the law of the arbitration seat, should have governed the validity of the arbitration agreement. Applying French legal principles, the court concluded Pakistan had not intended to be bound by the arbitration agreement and refused enforcement. The Dallah decision is seminal because it affirms the supervisory role of national courts in determining jurisdiction, even post-award, confirms that arbitral tribunals do not have final say on their jurisdiction where enforcement is challenged, emphasizes that the existence of a valid arbitration agreement is a prerequisite for enforcement, shows courts' willingness to examine factual issues like party intent, even when a tribunal has already ruled, and clarifies that competence-competence in English law does not prevent judicial intervention at the enforcement stage. This approach underscores that while arbitration promotes efficiency and autonomy, it is not wholly insulated from judicial review, especially regarding fundamental jurisdictional issues. A practical implication of Dallah is that challenging an award does not require going back to the courts of the arbitral seat. A resisting party may challenge enforcement in any jurisdiction where enforcement is sought, as long as it meets the Convention's exceptions. Critics argue this weakens the tribunal's authority and undermines arbitration's efficiency. Yet proponents argue it protects parties from being bound by arbitration agreements they never consented to, reinforcing legal certainty. Furthermore, Dallah reflects the idea that courts and tribunals should coexist. While tribunals may initiate jurisdictional determinations, final authority lies with national courts. Post-Dallah, the principle of competence-competence continues to evolve and is treated differently across jurisdictions. In Brazil, for example, Article 8 of the Brazilian Arbitration Law adopts a strong version of the principle. It states that the arbitrator has a duty to rule on the existence, validity, and effectiveness of the arbitration clause and the contract itself. This suggests that in Brazil, tribunals enjoy broader initial powers. However, Brazilian courts do intervene when compelling public policy concerns arise. For instance, the São Paulo State Court invalidated an arbitration clause in a franchise agreement, citing abuse and the lack of informed consent by unsophisticated franchisees. The court held that enforcing the arbitration clause in such cases would deprive vulnerable parties of access to justice. Judge Enio Zuliani emphasized that legal certainty and protection from fraud override strict adherence to competence-competence. Similar decisions have upheld court intervention, where clauses were inserted into contracts without negotiation or fairness, especially where arbitration would favor a dominant party. Thus, while Brazilian law nominally embraces competence-competence, courts will override this principle in exceptional circumstances, especially where inequality, fraud, or public interest concerns are involved. The Dallah case and Brazilian examples reflect ongoing tensions in international arbitration, such as, should tribunals be the final judges of their own jurisdiction? What is the appropriate role of courts at the enforcement stage? Can public policy override party autonomy in arbitration? The core issue is one of balance. Arbitration promotes efficiency, party autonomy, and neutrality, but courts are tasked with ensuring fairness and legal certainty. The doctrine of competence-competence must therefore be contextualized within a broader legal framework, where judicial oversight acts as a safeguard. Moreover, the UN Citral model law, adopted widely, reflects this duality. Article 8(1) requires courts to refer disputes to arbitration unless the agreement is null and void, inoperative, or incapable of being performed. This maintains a pro-arbitration stance while preserving a judicial check on tribunal jurisdiction. The doctrine of competence-competence continues to evolve under different legal systems. The UK Supreme Court's ruling in Dallah illustrates that while arbitral tribunals may initially determine their own jurisdiction, national courts retain the ultimate authority to rule on this issue when enforcement is challenged. In jurisdictions like Brazil, although competence-competence is strongly supported, courts will override it where necessary to prevent injustice or fraud. This reflects a pragmatic balancing act between respecting arbitration autonomy and safeguarding public interest and access to justice. Ultimately, the future of competence-competence lies in fostering mutual respect between courts and tribunals. Courts must avoid excessive intervention, and tribunals must operate with integrity and caution, knowing their decisions are not immune to review. Arbitration success depends not just on procedural autonomy, but also on its substantive fairness and legitimacy. Thank you for your interest in this topic. To learn more about arbitration law, take a look in our dedicated videos. We hope this lesson was helpful to you, and we are looking forward to seeing you again soon.